sitting day. Honourable Members, I therefore call on Government Order of the Day number 9.
Family Court Proceedings Reform Bill, second reading.
Mr Speaker.
I recognise the Honourable Minister, Judith Collins.
Thank you so much, Mr Speaker. I move that the Family Court Proceedings Reform Bill be now read a second time. The bill is an omnibus bill which amends 9 acts. The acts to be amended include the Care of Children Act 2004, the Domestic Violence Act 1995, the Family Courts Act 1980 and the Legal Services Act 2011. The bill will implement the government's decisions that are based on the findings of a Ministry of Justice review of the family justice system in 2011. The reforms will ensure a modern, accessible and sustainable family justice system, a system that supports children and vulnerable people who most need the family court's protection. The reforms are the first significant changes to the family court since it was introduced more than 30 years ago. The slow pace of resolving family court applications is creating additional pressures on children and families. Currently, Care of Children Act applications are taking on average 238 days to resolve. Domestic violence cases take on average 117 days to resolve, and relationship property applications are taking well over a year on average. The bill emphasises the needs of children and vulnerable people to ensure that ongoing support and protection for them. It clarifies provisions relating to care of children cases involving allegations of violence and improves the family court's response to domestic violence. The bill encourages parents to resolve matters themselves. Families will be supported to reach agreements and resolve disputes outside of court. The successful and free Parenting Through Separation course will be expanded, and a new out-of-court family dispute resolution or FDR service will be introduced. The bill focuses the family court on resolving parenting disputes that require a judicial decision. It targets the use of professionals, including lawyers, to help resolve the more serious cases. To help people to independently navigate the court for more straightforward matters, we will introduce improved information services, a simplified 3-track court system and easy-to-use forms. The government believes that parties should contribute to the cost of a lawyer used in family court proceedings unless this causes serious hardship. This view is reflected in the bill, which also allows for regulations to cap the proportion of costs to be paid by parties. The Justice and Electoral Committee has considered the bill. I thank the committee and officials and commend them for their efforts. There was significant public input in the bill. There were 386 written submissions and the committee heard 217 oral submissions. I have listened very carefully to submitters' concerns during the committee process. The modifications to the family justice reform support the government's key priorities: a court that protects vulnerable people, provides fast and efficient resolution of private disputes, and puts the needs of children first. And I'm very comfortable with these changes, and I have received positive feedback from many in the family justice community. The changes to the family justice reforms are to provide up to 4 hours of legal support prior to court entry for parents who meet the legal aid threshold, to provide up to 3 hours of preparatory counselling to help eligible parents to make the most of family dispute resolution, to enable a judge to refer parties back to family dispute resolution or parenting through separation courses if it is likely to help resolve the case, and to enable lawyers to participate earlier in the court process at the judge's discretion if they believe it would increase the chances of a successful resolution, and enabling provisions of the Act to be brought into force by order in Council as opposed to a specific date to provide greater flexibility in implementing the reforms. Cabinet agreed to these changes in April, most of which are now incorporated into the bill as reported back to the House. Additional legal support and preparatory counselling will be provided operationally. The bill, as reported back, provides family court judges with more options to help resolve disputes. Judges will be able to refer parties back to family dispute resolution or parenting through separation. Judges will be able to allow lawyers to participate earlier in the process where they believe it's going to help the chances of success. As a result of the changes to policy, parents may be provided with some initial legal advice prior to court entry. They may also be provided with some preparatory counselling to help them make the most of FDR. Currently, pre-court taxpayer-funded counselling is available to anyone on request for up to 3 hours. Under the reforms, the focus will shift from dealing with private relationship issues to resolving parenting issues and reducing conflict for the benefit of children. FDR will be free for the estimated 60% of the participants below the income threshold for civil legal aid. For those over the threshold, the cost of FDR is likely to be less expensive than retaining a lawyer and proceeding to a defended court hearing. The bill recognises that the family court should be one part of the wider system that helps families resolve issues. The court is often not the best means, though, for helping families settle disputes. The reforms in the bill are designed to support people to more quickly resolve disputes out of court where appropriate. They will ensure the court focuses on the most vulnerable and the most serious matters. They will also bring much-needed clarity to court processes and rules. Users will have more certainty and it will be easier for them to understand and navigate the court system. It's always good, I think, for the House to remember that when children are involved, that their parents one day, at one stage, loved each other so much that they decided to have children. And I think that's something that sometimes gets lost in the family court system. And as a lawyer of over 20 years' experience, I've seen it happen time and time again, where people's best interests have not been put first, but actually those of professionals have been. And I believe that this bill will help reduce that situation. As a result of the bill, the family court will better meet the needs of families today by reforming a system that was introduced into a very different world more than 30 years ago. Mr. Speaker, I commend this bill to the House.
The question is that the motion be agreed to.
Mr. Speaker.
I call the